This administration believes that birthright citizenship is unconstitutional.
Birthright citizenship is a core American principle, and it's under attack. President Trump issued an executive order attempting to deny citizenship to children born on American soil. This is a flagrant violation of the Constitution, specifically the 14th Amendment, and centuries of legal tradition. The principle that being born in a country makes you a citizen of that country goes back to before the Mayflower. The 14th Amendment clearly states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. The idea that being born in the United States makes you a citizen is a fundamental part of American history and tradition. Calvin's case, 1608. This landmark decision established the principle of jus soli, which holds that birthright within a sovereign's dominion automatically confers citizenship, regardless of a person's parentage or nationality. The key question in this case was whether individuals born in Scotland after the Union of the Crowns, known as the Post Nati, could be considered natural-born subjects of England. The Exchequer Chamber, after a hearing before the Lord Chancellor, ruled that Robert Calvin was born under the allegiance of the king regardless of the location, making him a natural-born subject of all the king's dominions. Fast forward to 1806 in Killam v. Ward, the key question was whether Asa Killam, born in the colonies, who fled after Lexington and as a carpenter helped build ships for the British Navy in Newfoundland, was an alien absentee. The court ultimately ruled in favor of Killam, affirming that his birth within the American colonies established a durable citizenship that was not nullified by his temporary residence in British territories or his engagement in British activities. The court recognized the primacy of birthplace over temporary allegiances. The case reinforced the historical continuity of birthright citizenship, a principle that originated in English common law with Calvin's case 200 years prior. In the case of Ingalls versus Trustees of Sailors' Snug Harbor in 1830, the court faced the question of whether a man born in the United States in 1776 was a U.S. citizen and therefore able to inherit real property. The court agreed that, quote, nothing is better settled at the common law than the doctrine that the children, even of aliens born in a country while the parents are residents, thereunder the protection of the government and owing a temporary allegiance thereto, are subjects by birth. However, Ingalls had been expatriated and remained so at the time of the Treaty of Paris, which fixed allegiances, unlike Killam, which had returned prior to. In Lynch v. Clark, 1844, a New York case addressed whether a person born in the United States to alien parents who resided here temporarily was a U.S. citizen, even though they left to live in Ireland. The case was about the rights to inherit a mineral spring owned by a company, Lynch & Clark. Thomas Lynch had died, and the question was if his niece, Julia, born in the U.S. to Irish parents who left with Julia soon thereafter, was a citizen and could inherit. The court ruled in favor of Julia Lynch, affirming that she was a U.S. citizen by virtue of her birth in New York, irrespective of her parents' status as aliens, saying, quote, natives are all persons born within the jurisdiction and allegiance of the United States. This is the rule of the common law, without any regard or reference to the political condition or allegiance of their parents, with the exception of the children of ambassadors who are, in theory, born within the allegiance of the foreign power they represent. In U.S. v. Rhodes, 1866, the question was whether a law barring people of color from testifying against white people, in this case those who burgled her home, was constitutional, and part of the argument was whether Nancy Talbot was even an American citizen given her race. The Civil Rights Act of 1866 stated that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States. The justices wrote to affirm the common law principle that, quote, all persons born in the allegiance of the United States are natural-born citizens, and that, quote, no warrant for the opinion that this great principle of the common law has ever been changed in the United States. In United States versus Wong Kim Ark in 1898, the court affirmed the right to citizenship of the United States of a child born to foreign aliens. Wong Kim Ark was born in 1873 at Sacramento Street in San Francisco, California, to parents of Chinese descent who were subjects of the Emperor of China. His parents were permanent domiciled residents of San Francisco, where they engaged in business and were never employed in any diplomatic or official capacity under the Chinese government. The court stated, quote, "The 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory, in the allegiance and under the protection of the country, including all children here born of resident aliens, with the exceptions or qualifications as old as the rule itself of children of foreign sovereigns and their ministers, or born on foreign public ships, or of enemies within and during a hostile occupation of part of our territory." They go on to say, "The amendment, in clear words and in manifest intent, includes the children born within the territory of the United States of all other persons, of whatever race or color, domiciled within the United States. Every citizen or subject of another country while domiciled here is within the allegiance and the protection and consequently subject to the jurisdiction of the United States. His allegiance to the United States is direct and immediate while in the United States and strong enough to make a natural subject, for if he hath issue here, that issue is a natural born subject." The court went on to say to hold that the 14th Amendment of the Constitution excludes from citizenship the children born in the United States of citizens or subjects of other countries would be to deny citizenship to thousands of persons of English, Scottish, Irish, German, or other European parentage who have always been considered and treated as citizens of the United States. Birthright citizenship is not just a legal principle, it's a patriotic one. It ensures equality by granting citizenship to all born on U.S. soil regardless of race, color, or origin, and is a necessary requirement for the fulfillment of the promise of inalienable freedom. This is a part of what makes America a special place and has been a strong and clear element of American law and our histories and traditions since the colonial days. Attempts to abolish birthright citizenship run counter to fundamental American values.